Good afternoon. First of all, thank you for inviting me to Florence. I'd like to thank the organizers of EUDO, and in particular Valentina Bettina for being very thoughtful in organizing all this. This is the first time I present this paper. It's also a first draft, so we are very much looking forward to your comments. In 2011 and 2012, the EU agreed a new set of rules for economic and fiscal surveillance of the EU member states under the Reinforced Stability and Growth Pact and the Fiscal Compact to strengthen the effective enforcement mechanism of both. Sorry? Ah, okay. So to strengthen the effective enforcement of both the Stability and Growth Pact and the Fiscal Compact, they introduced something like reversed qualified majority vote. When I saw this, all of a sudden I realized that I had seen this before, but in a different policy domain, both within the EU, but also outside the EU. And something, when I was coding voting in the Council of Ministers, something dawned to me that this had quite some profound impact on how you would behave as member states under such a voting rule. So this is where the idea came from to compare this. So the objective of the presentation is to answer two questions. The first one is, does reverse majority effectively strengthen the enforcement mechanism of fiscal governance? Yeah. And second, if you basically look at the use of reversed qualified majority vote, you will realize that the decision is not taken by a majority of member states, but the decision is taken by a minority of member states. And this immediately raises the second question, is what is the effect of the introduction of such rule on legitimacy? Yeah. Now, in order to answer the question, I needed to have comparative data on the use of reverse majority voting. And I looked at 3 cases where reverse majority has been introduced. The first one is the dispute settlement system in the WTO. It's the oldest case where reverse majority voting has been introduced, and more specifically a reverse consensus. The second one is the EU's anti-dumping policy, and there one introduced a reverse simple majority. And the third one I just mentioned. Yeah. Now, the focus of the paper is on the likelihood of a decision being adopted under reverse majority compared to the normal rule. Yeah. And for each, the paper considers the institutions and the procedures, and more specifically the voting rule. The causes and objectives of the reform introduced, meaning why did they introduce reverse majority vote? And the third one is the likely impact of the reforms. What are the data we're using for this paper? That is regulations, the rules and procedures, the literature, because for instance on the WTO case we don't have data, but there's lots of analysis done on how this works. And for EU anti-dumping policy, we use a new data set of EU member states' voting behavior in the area of anti-dumping policy for 2002 and then 2003 to 2007. That's 5 years of voting data, but there are some caveats you should take into account with respect to these data. Not all of these votes that have been taken have been published. Some are published, some are not. Yeah, and this is something you have to keep in mind. So for instance, for 2002 we have data, but 2003 we don't, and then from 2004 to 2007 we again have data. How do we look at it? We use comparative analysis and descriptive statistics. What is new? There's been much talk about this reverse majority voting, but actually little information is out there on how it functions, both hypothetically and empirically. So we look at reverse majority voting in a comparative perspective, both between cases and within cases. Why should we care about this? I'll give you some examples. Between 2004 and 2011, there has been an EDP for 21, an excessive deficit procedure for 21 countries out of 27 EU member states. If you go online on the website of the Commission, you will see that actually out of the 27 member states, 21 are in an excessive deficit procedure. From these 27, you have 13 out of 17 Euro member countries in an excessive deficit procedure. My question to you would be, if you have a vote in these groups, how would a vote on enforcement turn out? Do you think countries would actually, when they get a recommendation from the Commission and they have a qualified majority vote, would they vote on each other? So this is where the whole research started out. In 2010, and this was immediately after the Commission proposed its first reform under the six-pack, so the 5 regulations and the 1 directive under the six-pack, whereby a full automatic mechanism of reversed qualified majority was introduced. And there was quite some argument on these proposals. And Christine Lagarde, she said, well, if you look at this mechanism, it's going to be a total automatic mechanism, and it hands over the power exclusively in the hands of experts. This was a very strong position at the time from France. But now let's first look at the oldest case where we found reverse majority voting, and especially the reverse consensus. The WTO procedures from 1947 basically say that whenever you have a dispute between 2 member states on the area of trade, you need to decide by consensus. This system worked quite well up to the 1980s. In the 1980s, you had delays in the disputes between the member countries of the WTOs. These delays were related to the veto. The consensus or the unanimity were related to the veto that an individual member state could have. So whenever there was a complaint by an EU producer filed, and the whole mechanism was set in force, the member state that was actually accused of not following the rules, he could block the system. So by the 1980s, you had delays, you had negotiations, trade-offs between different negotiations that were not related. In a sense, the problem was that the system was no longer predictable, it was no longer functioning properly, and it was no longer credible. So by 1994, actually by the beginning of the Euro round, between 1986 and 1994, the member states of the WTO agreed that urgent reform was needed in this area. And so what did they do? They introduced, only for the dispute settlement mechanism, they introduced reverse consensus. They did so for key steps in the procedures, and they did so with strict time limits. This made this system not only highly efficient, but it also made it binding on the member states. Now, how should you look at this reverse consensus? It meant that if you brought a complaint, and within the structures of the WTO you had a panel that decided that the complaint was valid, and this panel would submit the complaint to the political body that ultimately decided upon it, that only one member state could say, yes, this is okay, and that it would pass. So this is an extremely high threshold, voting threshold. If you know that in 2012 we had more than 150 members in the WTO, you actually have a majority, you need less than 1% of the total membership to basically agree on a decision becoming definite. So you have virtual automaticity, you have a very effective and expeditious decision-making mechanism, and the system becomes highly predictable and credible. However, there were some unintended consequences for accountability and legitimacy in the WTO. First, a number of observers basically said, if you have such a virtual automatic mechanism under such a voting rule, member countries that agree on retaliating measures, for instance, they are held accountable. And most citizens in these countries, they do not really understand that the mechanism, the voting rule, is automatic. So they will hold their governments and the country responsible and accountable, while the decisions that are taken, they actually reside somewhere else, in the appellate body and in the panels. Moreover, they will also argue that the minority decides and not the majority. And given the efficiency of the mechanism, these decisions become highly intrusive on the member countries. In other words, the exit option for the country against whom the complaint is filed are basically nil. So, and then the last point that a number of observers have made is that you get actually two speeds in decision making. You get within the WTO, you get a system that is highly effective and highly active. So it does its job really well, and member countries are very happy with it. But on the legislative side, they didn't introduce any changes. So there you have the majority, you have the consensus rule still in place. As a result of the activity going on within the dispute settlement, the legislative side cannot really formulate an answer with the same speed. And so you get tension between these two. So we looked at the first case, the dispute settlement system in the WTO. Now we go to the EU anti-dumping policy. Here we have reverse simple majority. Basically, anti-dumping policy in the European Union works as such. You have a producer who files a complaint with the Commission. The Commission looks at the complaint and basically does an investigation whether this complaint is valid, yes or no. Then it goes to the advisory committee and it consults the member states. Then finally this goes to the EU Council and the EU Council votes on this. There have been 3 different voting procedures in place. The first one was qualified majority up to 1994. 1995 they lowered the threshold to simple majority. And in 2004 the threshold was further lowered to a reverse simple majority. Yeah. Now, what is interesting about this is that when you have a normal voting rule, any member state that abstains is counted as a vote against. When you have a reversed majority rule, and this is crucial, any member states abstaining is a vote in favor of the decision. The dynamic is totally different in this respect. Now, the change was actually introduced because the Commission no longer had the decision-making capacity in an area such as anti-dumping, whereby time is critical. When a producer in the European Union files a complaint, he's basically suffering from dumping in the market. So it is necessary for the mechanism to be fast and expeditious. This is why the Commission saw that it needed to have decision-making capacity in this area. Now, with the breakdown in the early 2000s, there were a couple of decisions made that were rejected in the Council. And these decisions were rejected not because there were lots of member states voting against, but because there were quite a number of member states abstaining, counting as votes against. In other words, the Commission was no longer effective in its mechanism, and this sort of posed a very difficult issue for the Commission, because on the one hand, it had established that there was reason for launching anti-dumping, but on the other hand, the procedure was basically blocked. It could not go further because the Council rejected it. Yeah. So there was a reform, and they introduced reverse simple majority voting in key steps in the procedure, and again with strict time limits. Now, the impact of that, as I said, is abstentions count as votes in favor, which means that you already shift the direction into approval. But more importantly, your fixed threshold, majority threshold, becomes dynamic. I'll explain this with an extreme case. In an EU of 25, it is normal, under a normal procedure, you have 50 plus 1. Under a simple majority, you need 50 plus 1 in order to approve a decision, with one member state counting as one vote. Under a reverse majority vote, this threshold becomes dynamic, because what actually happens is your abstentions, they count as votes in favor. So in the extreme case, you can have 12 member states voting against, 12 member states abstaining, but one member state, let's say Malta, voting in favor, and your decision is approved, meaning you have a majority threshold of 4%. Yeah? Now, when we look at the data on voting in EU anti-dumping, you see the following. So first, the interesting bit is between the rule before the introduction of reverse majority voting and after. You see that before, 73% of the member states basically on average in 2002 voted in favor. But from 2004 to 2007, this goes even up, in the beginning at least. So the average is even higher. But most interestingly is the behavior of member states under this new rule in terms of the majority threshold. This threshold gradually goes down. It doesn't go down very much, but there's a tendency of going from 47, is the last column, from 47.3% up to 36. This means that increasingly a smaller number of member states are approving the decision. It means that the minority actually becomes increasingly determining for the decision being approved within the Council. And then there are a couple of cliffhangers that actually made the Commission decide that this was even more a predicament. And those were in 2006. We also see that member states change their voting behavior in this context from voting in favor and voting against, from voting in favor and afterwards abstaining. So abstentions become very important. Now you have to consider this in the context of the EU Council on the excessive deficit procedure. It means countries that are basically tacitly saying, we don't want to have anything to say with this, but we agree that their vote actually becomes very important because unwillingly or willingly, they lower the majority threshold for the decision being approved. And this is where the dynamic threshold steps in. Yeah? So the impact is lowering the majority threshold, changing the voting behavior in the Council by the member states, and a willingness to lower this majority threshold. So decisions can increasingly be approved with a minority, and discretion moves actually towards the Commission, to the right of initiative. So we looked at those two cases, now we look at the SGP and the Fiscal Compact. And here we have, I'm immediately going to show what this means for the Fiscal Compact and the SGP. In 2003, there's this famous vote that everybody knows about on an excessive deficit procedure against France and Germany. The entire procedure took about 2 years, from the Commission basically writing a report on the excessive deficit, filing an opinion on the existence of an excessive deficit, to Commission recommendation on the decision of the existence of an excessive deficit, to a recommendation for a Council recommendation on to end the excessive deficit situation. This resulted in a vote which was not anticipated, and many people regretted that the fact that this vote took place, but this crucial decision basically weakened the Growth and Stability Pact to a large extent. And it's very similar to what happened both in the anti-dumping area as well in the WTO. There was a breakdown of the enforcement mechanism. So, and here we see a breakdown of the EDP. Now, what actually happened in the total 8 steps, just the step before the sanction mechanism of the EDP kicked in, the Council had a vote. And it actually had 4 votes plus 2 votes. And here are the votes on that one. And what we see is, contrary to what you read in most of the analysis, the vote was not taken with a qualified majority, but it was taken with a 2/3 majority. If it would have been a qualified majority, it would not have passed. And actually for the decisions on France and Germany, the 4 decisions, there was a 20% rejection, meaning there was quite some leeway on behalf of the member states to reject it. It became only a cliffhanger, so the whole procedure was set in motion, but when the Commission established that there was an excessive deficit, the whole procedure was set in motion, and then the Council basically said, we reject it. This meant that even if the Commission agreed that there was an excessive deficit, nevertheless, it had to accept the fact that the procedure stopped. and it tried to find a way around it by formulating council conclusions. The last step in this was that the Commission really needed to be credible in this area, and it went to the ECJ. And the ruling of the ECJ in this area was that on fiscal policy, this fiscal policy was in the area of the member states, but nevertheless, if the council rejects an EDP procedure, it really needs to state why it does so. Okay. So after these decisions, the pact was left very weakened. Sorry, I need to go back. So then we have the proposals of the Commission in 2010. And the proposals introduced full reverse qualified majority voting in the procedure for key steps, both in the SGP and the Fiscal Compact, and with strict time limits. The impact of that was almost virtual automaticity. Would it not have been that between the proposals of the Commission and the final text of the SGP, you see that all of a sudden you have reverse qualified majority in the first step, but then you get qualified majority subsequently back introduced, and the two cancel each other out. And when we did the simulations on how this would have turned out in the 2003 case, we actually discovered that under the Lisbon rules, the decisions of 2003 would not have made it, and the excessive deficit procedure on France and Germany would have worked. But if you go to the Lisbon rules and you apply the Lisbon rules, you see that the threshold goes down and the decision would have passed. And this brings me back to the Lagarde quote. You start wondering what actually happened to the SGP that was proposed by the Commission, and finally the text of the SGP. And you see actually that there's not much change. But where does this change come from? It comes from the Fiscal Compact. And the Fiscal Compact basically reintroduces full RQMV in the entire procedure. But as Bruno de Witte this morning said, the Fiscal Compact apparently has a secondary status to EU law. So it depends on how this will work out. Yeah. So virtual automaticity, the discretion moves towards the Commission, and you get issues of legitimacy because there's a minority ruling. You get 27% of the member states that decide on such a recommendation with a binding effect. And again, you should ask, we asked ourselves, how does this look? The Commission decides in this area, but the Council basically approves this with a voting rule. Who is going to be held accountable in the member states? And it reminds me about a quote from Magnet, the federal minister in Belgium, who a couple of months ago said, "Who is Olli Rehn?" And he exactly was looking at this. He said, the Commission is basically having an impact on our budget. So we looked at all three. My conclusions are, does reverse majority effectively strengthen the enforcement mechanism of fiscal governance? Yes, automaticity in key steps and time limits. The minority rules, but much depends on the status of the Fiscal Compact. What is the effect on legitimacy? The Commission decides, the member states are held accountable. And many citizens will not understand how this discretion works. It very much reminds us of the whole debate on discretion versus rule-based systems in central banking, whereby you have the Fed representing the discretion, look at things, and the rule-based system is the Bundesbank. Again, you have this here popping up. Now, this brings me back to the beginning. How will the Commission fulfill its role? If the discretion goes in the direction of the Commission, what will the Commission then do? Will it reflect the majority of member states in the EU? Or will it really interpret its role as the guardian of the rules? And this is still very much an open question. Thank you very much for your attention.